Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you.
Good afternoon. Thank you everyone for coming to today's program. My name is Anna Fairfield and I am with ADR Services, Inc. And it's a pleasure to have you here for Mastering PMK Depositions, Perspectives from Both Sides of the Table. So thank you very much. And with that, I will introduce our moderator, Judge Elizabeth Pfeffer. As a judge of the Los Angeles Superior Court for 13 years, Judge Pfeffer served in various roles, including in limited jurisdiction, civil independent calendar court for 6 years, a civil trial court for 3 years, and family law court for 4 years. During that time, Judge Pfeffer presided over more than 75 civil jury trials, more than 500 civil bench trials, hundreds of evidentiary hearings, and numerous settlement conferences with a diverse range of complex, factual, and legal issues. Judge Pfeffer has handled a wide array of cases, including employment litigation, professional liability, personal injury, elder abuse, products liability, business litigation and partnership disputes, real estate litigation, land use litigation, eminent domain, insurance coverage, insurance bad faith, and entertainment cases. As a neutral mediator, arbitrator, and referee since 2020, she has an impressive track record of successful settlements across a broad spectrum of civil cases, reflecting her varied assignments on the bench and prior civil litigation practice, which is representing both the plaintiff and defense. So with that, I will turn it over to Judge Pfeffer.
Great. Thank you, Anna, for the introduction. I appreciate it. I am really excited about today's presentation and honored to be here. We're joined by 2 just outstanding, highly experienced litigators who have a ton of practical tips of stuff I wish I knew when I was in private practice back in the day. They're going to share their perspective from the plaintiff side and the defense side. They're not just experienced trial lawyers, but they've been volunteer mediators on the U.S. District Court's panel, and they're also neutrals with me here at ADR Services. So, appearing for the plaintiffs, Sanford Johnson, we call him Sandy. He's been practicing law for over 42 years. He has extensive experience in sexual molestation cases, personal injury cases of all kinds, premises liability, police excessive force, habitability, government claims of all kinds. Sandy especially focuses on cases with sensitive subjects and people. He's twice received the President's Award from the Consumer Attorneys Association of Los Angeles. He was also an adjunct professor at the Strauss Institute for Dispute Resolution at Pepperdine University School of Law. He's been arbitrating matters for over 35 years. He's mediated thousands of matters, and he's been an arbitrator and a mediator here at ADR Services since September 2023. So thank you, Sandy, for joining us. And
thank you for having me.
Thanks. And for the defense is John Gulper. He's an ABOTA member whose nearly 5-decade-long litigation practice is focused on labor and employment cases, as well as business litigation matters. Throughout most of his career, John represented large corporations and often dealt with PMK depositions on their behalf. In 2017, he went to an of-counsel basis with the law firm he co-founded, and he started working as a part-time mediator. In addition to continuing to mediate district court cases, John has also been with ADR Services since January of this year. So again, welcome, John.
Thank you.
Thank you. So I know the attendees here have written handout material, so I'm not going to read the statutes. That would be boring and take away time from our 2 panelists. But just briefly, you have the statutes in the materials. We have CCP section 2025.010. We have 2025.230, which deal with when the deponent's not a natural person. The notice has to describe with reasonable particularity the matters on which the examination is presented, and the deponent is to designate and produce a deposition, those officers, directors, managing agents, et cetera, who are the most qualified to testify on its behalf as to those matters, the extent of any information known or reasonably available to the deponents. And yes, it is, I know the statute says person most qualified and not person most knowledgeable, but we'll colloquially refer to them as PMK depositions. And we also have, so the context with a subpoena, CCP section 2020.310. Again, these are all in the materials, so I won't read it. We also have the Federal Rules of Civil Procedure, Rule 30b-6. And it talks about, who's going to be, designated to testify. The person designated must testify about information known or reasonably available to the organization. So the counsel we have here obviously have a wide range of experience of all types of personal injury, sex abuse. Obviously, there are products liability cases. We've got labor and employment. So there's a wide, variety of civil cases where you'll see a PMK deposition notice. So these will mainly focus on where the plaintiff is seeking the testimony of the PMK of a defendant, organization or, entity, et cetera. So with that, questions for the plaintiff, Sandy. So these PMK depos, like what's kind of the aim? What's the point? What do you look for when you're crafting the deposition notice, the document request? And what's the strategy behind actually taking these depositions?
Okay, strategy is the key word. The first thing you want to think about is how does your PMK deposition interlock or interact with your client, excuse me, and with your expert. You want to, before you do your PMK depo, you want to understand what kind of cases you're going to have a PMK depo in. Typically, it's going to fall into 4 categories, where there's a governmental entity, where there's an institutional entity, where there's an employee involved, or where there's a professional. You're obviously not going to have a PMK depo where it's a fender bender and it's just the plaintiff and the defendant. Next thing you want to think about is strategy. The macro strategy is what I just described. Before you do your PMK depo, you want to do a request for production of documents. You want to be asking for policy manuals, personnel manuals, possibly job descriptions, those kinds of things. So you've got a general sense of what's going on. Then you want to focus down on what it is exactly that you're doing. You have to look at the kind of case that you have, and you have to understand the facts involved in that case. For example, if you've got a case involving a trucking accident, you have to understand, you have to be in the mind of the truck driver. You have to be in the mind of the employer employing that truck driver. If you've got a medical mal case or a police excessive force case, whatever it is, you want to understand what that person does and how that they do it. How do you do that? Number one, you want to go on the internet. For example, none of us, probably most of us, don't operate a backhoe. You can find the information and how to operate a backhoe on the internet. The second thing, and what I think is really a nugget to offer here is don't wait until 50 days before trial to contact an expert or to engage an expert. Before you do a PMK depo, it's worth spending the money to engage an expert for an hour rather than having to fully retain them and learn how it is that the category of person that you're deposing, how they do what they do, so that when you fashion your notice of PMK depo, which remember is both a notice and request for documents, you know specifically what to ask for. All right. What is it you're looking for, and what is it that you want to accomplish? Well, if you're a plaintiff's attorney, you've got your plaintiff who's going to establish that a breach occurred, some of the aspects of proximate cause, and the damages. What you want to do with the PMK is you want to get standard of care. You want to get the proper way that the defendant should have been doing whatever it is that they're doing. When you do your PMK notice, you want to request the resume of the person that's going to testify. You want to request the job description of the person that's going to testify. You want to request any policies having to do with the nature of the work of the person that's going to testify. So in any case where you have an employee, you need all of that information. When you're doing that deposition, you want to start out, I mentioned that you want to think strategically. How does this deposition interlock with the plaintiff's deposition, the defendant's deposition, and the expert's depositions that are going to be coming down the road? Oftentimes, John is going to probably say something else, but oftentimes I find that PMKs have not been briefed. They don't understand your case or what the facts are of your case. And sometimes they don't know much of what's going on. You want to set them up, essentially, by starting out with safety. Because in every case that we have, whether it's a sexual molestation case and it's an issue of supervising the children, or whether it's a police excessive force case and it's an issue of when you pull out the gun or the taser, or what you do in different circumstances, or whether it's operating a truck or a FedEx truck or an 18-wheeler or whatever it may be. In every case, safety is going to be the apex from which you begin your inquiry. Of course, when you ask them what is the most important factor, they have to say safety. And if not, you could lead them into it because they're an adverse witness. And once you get them to say safety, then you want to go through the procedures that have to properly be followed in accomplishing the safe operation, whatever it is they may be doing, whether it's a medical malpractice case or, again, a truck driving case or some other type of case, premises liability. What is the safety concerns involved in having a clean floor? How many inspections? How often? What has to be done when doing these inspections and cleaning, etc. So you start out with that macro concept, and then you want to focus in. Because what you're thinking is I want to take this deposition and give it to my expert, and I want to take this deposition and impeach their expert with their own PMK. That's how it all fits together. And that's the strategy that you want to be thinking about when you do these depositions. Have I answered your question?
Yes, no, that's great. Thank you, Sandy. And so for the defense, so John, so you're on the receiving end of PMK deposition notice with 30 categories of stuff and all these requests for production, and you're the receiving attorney. What do you do? Now, I know you wouldn't hand that off to the junior associate, your firm, but what do? You get the PMK deposition notice. You're the defense attorney. Walk through, what do you do with it? Going to your client, getting the PMK designated, et cetera.
Well, yeah, my practice, I was very fortunate because I represented a lot of large corporations over the years. So it was very different than when I would have a smaller client that was not very sophisticated. Usually the larger corporations are pretty sophisticated, especially in the employment area. They've got HR professionals, VP HRs, et cetera. But I think as a receiving person on these PMK notices, the first thing you do is look at every category that's being asked, whether it's got an attached request to produce documents or they've already been produced and now it's just the PMK notice that's coming. But one way or the other, you need to study every category. What is the plaintiff trying to get when they sent that? What do we already know? If you know enough about your company, fortunately, I had companies that I'd represented for 25 years, so I knew them backwards and forwards. But as an employment lawyer, you got to know your client really, really well. You got to know what their HR practices are, because then you can match up what you already know to what those categories are. And that's the biggest thing is studying the PMK deposition. Frequently in the employment area, we want any and all policies of blah, blah, blah. And the any and all within the employment area generally is overbroad. So you're looking to see whether the categories being asked, the way the propounding party has phrased everything, is it overbroad? Because frequently, you don't want to have to produce a PMK representative that has to review 1,000 personnel files in order to answer a question. And you have proportionality requirements in federal court, not necessarily in state court, although my experience was you use a lot of the practices from federal court, and it's very persuasive in the state court. But if you know as a receiving end, you need to study that PMK notice. You need to study each single category. however many categories there are. Figure out which ones are relevant to the real issues, which ones are just ridiculous over-seeking by the plaintiff's lawyer, and then figure out, match it up to the facts that you already know, and then ultimately you're going to end up meeting with your client anyway before you do anything. And sometimes I can look at one in 10 minutes and know that no, this is never going to fly. We're going to have a lot of meet and confers on this one. And keep in mind, in federal court under Rule 26, you've got meet and confer obligations the minute the PMK notice goes out. It either should have been discussed beforehand or after you get it. It's right in Rule 26. So you've got meet and confer. You don't have that in state court, of course, but the state courts are starting to adopt some of the good procedures from the federal court, in my opinion.
Well, it seems a good practice would be you're on the receiving end, defense counsel, you have a PMK notice with, the huge RFP with 25 different categories. At what point do you reach out to the noticing plaintiff's counsel and say, hey, these 25 categories, 2 are ridiculous, and you have a discussion about that, but we actually have 3 different PMKs for these different subjects. When you produce the documents, how does that conversation go down with plaintiff's counsel? Because certainly they would want to know if it's one person showing up or you have 20 different PMKs, each for every different category.
Well, the better practice is you are going to figure out as you completely analyze the notice and the categories, you're going to figure out at some point in consultation with your client, are you going to have multiple people doing this, or are you going to slap one person with the obligation to answer 30 categories? And that's a whole different animal, when you're doing it, figuring that out, because that's a whole analysis that you got to figure out how you want to do it. If you have some plaintiffs' lawyers, you can get away with one person to answer 30 different categories. Some really sophisticated plaintiffs' lawyers in the employment area, I think you're risking a lot of problems if you just have one person covering multiple topics. You really do want to pick different people. And you're entitled to pick different people on the defense side. You don't need to get the approval from the plaintiff's lawyer on that. You can make that decision yourself, but that's a whole strategy decision, and you're going to cover that with your client. Big companies have a general counsel. Usually they'll have an in-house employment counsel, so you go over that with them. But those are all strategy decisions, and some of the topics are so broad. Okay, we can pick one person. You also figure out, if you have somebody that's a very experienced HR person, you can probably use that person to answer multiple topics. But if you're talking about a specific, for example, in a disability discrimination case, interactive process, you need the people that actually engage in the interactive process, probably. But then frequently they're going to ask also questions, what is the general policy of the company? So the biggest thing to do is study the topics, know what your client, what the case is about, and start to figure out who you're going to designate and how you're going to designate. Ultimately, on the preparation end, you're going to want to do that. But you can designate, you have the right as the responding party to designate whom you want. You just need to make sure that they're properly prepared enough so you don't get slapped with some kind of emotion later on because you had somebody that was completely ill-prepared to respond. I never allowed that to happen. So,
Okay.
It's key. It's key. You can't play around with these, in my opinion, because if you get a plaintiff's lawyer like Sandy, they're going to kill you at trial if you prepared somebody, you designated somebody that didn't know what they were talking about.
Right. Well, yeah, and right. And that would be the point, kind of segue to Sandy. I mean, in a way, that's kind of the dream of you're taking a PMK deposition of someone who really doesn't know much at all. So how do you deal with that situation? I had cases on the bench where I would get plaintiff's counsel would come in and say, we took this PMK depo and the PMK didn't know much at all of anything. And so, what do you do? Do you then do more discovery to get the next person, the next person, the next person? How do you deal with the situation when you have the PMK who knows really not much at all.
Is that a question for me?
Yes, right. What do
Well,
you?
it was a question to me.
Yeah,
Okay.
and then I'll get to John. What do you do when that's your client? But Sandy,
Well-
what do you do? You're taking the you know in advance who these people are, what they're going to be testifying about. You have the documents, or maybe they don't have documents, but you're taking the deposition, and it's clear that the PMK really doesn't know much of anything at all. What do you do?
Okay, first of all, this is not unusual when you have an institutional defendant, for example, a county of LA or something like that. You'll see a lot of times that people will sign discovery. If you take their deposition and you ask them, well, did you do any personal investigation to determine the answers to these questions? Oftentimes you're going to get a no. This is great stuff. When you get a deponent, first of all, when you are doing that deposition, you've done your homework. You've booked an hour with an expert. You said to them, what is the standard of care with respect to this particular operation? You've got a list of documents you're requesting. You're prepared to do that deposition. When you start that deposition, the first thing you do is ask, are you the person most qualified in each of the categories that you've listed? They're all going to say yes, because they've been picked for that. You ask them whether they've produced all of the documents that you've asked for. They may or may not say yes. That's when things may start to go sideways. If they say that they are the PMK, you ask them, how long have they worked there? How many times they've been designated as PMK in the past? What materials they've relied upon in order to provide the deposition testimony they're going to provide today, who they've spoken to, and what information they've been given. Once you get all that, when you start focusing in, hammering down, common term, drilling down or whatever, if they start saying they don't know, smile broadly, say nothing, keep on going, and then prepare your motion in limine down the road to prevent anybody else from being offered to testify on those particular categories, because your defendant, your defense counsel designated somebody in particular. You relied upon that. They have a duty to be forthright and to disclose, and you relied upon that. So they don't get a second chance to put up somebody else to say, oh, they didn't know about this, I know about that. Okay, so you button it down, you hammer it down, and then you go in and you try your case with the testimony that they didn't give you, that your expert is now reviewed and laid out the standard of care and explained how the defendant in the case did not breach the duty and did not comply with the standard of care.
Good. There may be a scenario, again, it may not come up often, but where there's potentially a negligence per se cause of action that you want to bring of, there's a statute out there, the statute requires policies. The PMK says, well, we don't have a policy, and they may have one, but of course, if they produce the policy that they have to have pursuant to statute, then you can show it's negligence per se. So the defense may just offer up someone of, oh, we don't have a policy. We don't have any documents. We don't have anything. And what do you do in those type of situations?
Well, it's, where they don't have anything. I mean, this is helpful for you. What you do again is you smile broadly, okay, to yourself. And, you say to yourself, well, this has increased the value of my case. And when I go to mediation, this is something I have to emphasize, that they have no policy. Remember, part of your PMK deposition is going to be, you're going to be asking about hiring. You're going to be asking about investigations, typically. For example, if you've got a premises liability case, how often do you check these sidewalks? Or how often do you sweep the supermarket? What do they do when they do these things? If they have no policy, for example, I have deposed PMKs for cities that have no policy with respect to inspecting sidewalks and nothing written. I mean, in a government code 835, dangerous condition of public property case, this is great for the plaintiff when they tell you that. And after you've asked all the questions to establish that they are the PMK, the last thing you want to do is have them present somebody else. This is great stuff, because this establishes that they have breached the duty to act reasonably.
That makes sense. Again, John, again, potentially nightmare scenario for the defense. You've got your entity client who says, this is the PMK, and the PMK really doesn't know much of anything at all. I mean, in the prep phase, is that when you go back, maybe the general counsel, and say, hey, you got anybody else? Or what do you do before the deposition of, I don't know. What do you do up to that point? And then if it's kind of too late and in the deposition, the client's designee really doesn't know much at all, how do you deal with that?
You know, the guy that was made judge of the year by ABOTA this year talked in terms of, know the facts of your case, not the facts of the case you wish you had. And all I can do from a defense side is when you have a complaint filed against your client and the general counsel or whoever sends it to you to handle, investigate the case as quickly as you can. You got to know your case. And, once you know the case and you know your facts, you will probably be very instrumental as the lawyer in recommending to them who the PMK is. I very seldom, it was fine for the client to say, well, we want this person to be our PMK, but I'm the lawyer. And if that PMK doesn't really understand the issues, you can sometimes tell the client, you want me to spend 40 hours prepping this person? How about this other person who probably I only need to spend 10 hours with to prepare to work with them? Because one of the issues in PMKs is you are entitled as the deposing lawyer to ask them what they did to get prepared for this. How much time did they spend? I mean, I can't imagine a plaintiff's lawyer that doesn't ask that question. Because if you had a dopey person on the defense side and I spent about an hour looking at a couple documents. I mean, Sandy's just going to be going, his smile will be from ear to ear, on something like that. Because, you need to prepare. You have an obligation. There's a plethora of case laws, especially in the federal court, where the amount of preparation was the issue. Was it a proper PMK designee? Was the person properly prepared? The question is going to get asked them. How many documents did you review? But it's the obligation of the lawyer. Know your case. The minute it comes into you, you see what the allegations are. Meet with your client. Meet with our people, and get to know everything so you can figure out how you're going to respond. Because in many, probably 2/3 of the employment cases, a PMK deposition will be taken. You should assume it. So
that makes sense. So John, on the kind of the flip side, if you are kind of stuck with the situation that you're, the PMK really doesn't know much at all, and you get the plaintiff's counsel says, well, who would know the answer to this question? We want to reserve time and come back later. How would you deal with that? Would you say, look, this is the person, there is nowhere else? Or what? How would you deal with the plaintiff saying, well, we want to go to the next level, up and up and up?
Well, let me ask a preliminary question, assuming facts, not in evidence here, Your Honor. Does a person really not know? Does the company really not know? I mean, you will have some situations where the information is really not, you're talking something 20 years ago, and it may not be available. But assuming that it's a company that should know the answer, I would rather always have a second depo or a third depo, because I don't ever want to go to trial where somebody's going to play a video of a deposition and my person didn't have a clue what was going on and made a fool of himself or made a fool of the employer by testifying, I don't know, I didn't look at anything. So I'd rather the plaintiff's lawyer say, I would like to take a second depo or a third depo. I'd rather that be my case than the one where I'm stuck with the witness who didn't have a clue what they were talking about. So I can only think of a few situations where I would say, I don't want a second or a third depo. I'd rather have my case fully presented And I'd rather have all the facts out there so I know what it is I'm going to try 2 years later. So there are going to be exceptions of that, but that's generally my idea. And a lot of all this goes to people, I don't think, pay enough attention. Like if you're in federal court, the one thing you should look at is there's going to be more decisions you're going to see about that judge or the magistrate that's assigned to the discovery matters. So you can get a pretty good sense somehow how they handle these kinds of things, and you should orient yourself. There's not that much in state court. It's hard to find stuff about judges and what their rulings are. I mean, if you belong to ASCDC, you'll send out an inquiry early on in the case. I got an employment case out in San Bernardino. Anybody know anything about this judge? How's that judge handle motions to compel, blah, blah, blah. And you may get some information. CELA does that. They do a very good job sharing information. CALA, Sandy, you were probably, weren't you the lead guy, you won an award a couple times from CALA. So you'll know that the organizations are very helpful in getting information out about the judges. But you yourself as the lawyer, even if you don't belong to one of those organizations, see what the judge you're assigned to. Like in federal court, if you don't do that, I think you're crazy, because you can usually find something. You can see the history. Like the people being appointed now are very different than the people that were appointed 20 years ago. But you'll look at their background, so you're going to see what they're like.
Yeah, that makes sense. So Sandy, I've been monitoring the Q&A in the chat for questions. And so one question that, arose is, look, it's certainly, golden when you get the PMK who's a know nothing, right? Especially when it's on videotape. But one of the questions, attendee does is, a plaintiff's counsel who does get the know nothing PMK, you can ask who would know the answer. Can you go to court, get relief? And kind of the question is, if you don't do that, have you somehow, waived any of your client's rights if you don't just keep trying to, well, who would know, and just keep going up and up and up?
I was thinking of that question before you asked it. I think that's a question really for you to answer, and I'll tell you why. Okay. Who has the duty to designate the PMK? Certainly not the plaintiff. Okay. The defendant has the duty to designate the PMK. The plaintiff has a right to rely upon that designation. It is an important foundational question, just as John said, just as one should ask what you've relied upon to testify today, what conversations you've had other than attorney-client privileged conversations. You should certainly ask, is there anyone here, or is there anyone, that would know this subject better than you? And who are they? One could ask that. But if the defendant designates a know-nothing, or the defendant doesn't do their homework and prepare, or whatever the case may be, from a judicial perspective, why should the plaintiff be disadvantaged? Why should the plaintiff have a duty to say, well, you didn't give me a person who knows about the categories I've noticed you to produce somebody for? Do I have a duty to say, well, they didn't know anything? Let me try again. I don't believe so. I would argue not. The question that I have for you, Your Honor, is what is the perspective from the bench? I would think, and maybe I'm wrong, and John, I'd like to hear from you, with the exception of testimony and evidence that is subject to some privilege, why shouldn't discovery be open? Why shouldn't one encourage discovery? Because I believe that's what the code provides should occur. And that's what I think the cases say.
Right. I mean, obviously it's the adversarial system, and, judges have different philosophies on discovery and whatnot, but I mean, my position would be, this is, the notice went out. These are, first of all, are these proper categories and questions? Are they objectionable? But assuming they're all good, defense, this is who you pick. Just like, this is the expert you hired, right? You hired this really unlikable expert this is who you picked. Right. Yes.
I just want to say something because there is a unique niche here. Okay. Products liability cases. Yeah. Who would be this person most knowledgeable with respect to the design of this product that was designed 20 years ago? Tough area. Okay.
Right.
Now, another area is the sexual molestation area. Now that we have these look back statutes, and I am the person that brought the original case against the County of LA involving McLaren Hall, which shut down McLaren Hall. So I know this stuff. You know, what was the policy 20 years ago with respect to the supervision of children in this particular facility? Okay, who's going to be the PMK in that? Very difficult problem for the defendant. Very difficult problem for the defendant. In that area, it's going to be, you're going to have a different scenario than an area where you're deposing the UPS, the FedEx, the company with the 18-wheeler truck, or the post office or something, or Metro bus or whatever it is, with respect to what are the policies and procedures for training this driver? What are the policies and procedures for inspecting this bus? What are the policies and procedures with respect to drug or alcohol testing this driver? What are the policies and procedures for how often is this driver tested with respect to their driving proficiency and their physical acuity as far as their eyesight and such? There should be somebody on the scene now who's going to know those things, just like there should be somebody in an employment context who's going to know about investigations and discrimination and all of those different things, unless you're asking about what the policy was at that job 20 years ago. But then you've got statute issues and all that, so it probably isn't going to go back that far.
Right. John, do you have any thoughts on that? Kind of that tricky issue.
What was your initial question again?
Well, the issue was when you've got kind of the know nothing deposition, the PMK, and you go to trial, and the defense says, well, you didn't complain. We produced this person who didn't really know much. I say, well, it's kind of Sandy's position is, well, this is who you picked. The person you picked binds the company, so it's a very thoughtful decision.
I think as a trial lawyer, I'd be perspiring, but
you can't hide. Look, we all know you can't hide the ball. Excuse me. And there's tons of case law that it's not trial by ambush. But let's talk about the flip side for a minute.
Right.
Okay. What about when you get, the person who's, yeah, I'm the one. Okay.
Right.
I mean, you start out at that apex of safety, and oftentimes you get people that want to talk, excuse me, and they want to tell you how their company is safe and they follow all these practices and procedures. What do you do then? What you want to do is have them walk down the road of all the things that their employees should be doing, okay, so that you can establish that your defendant didn't do those things. Let me just say something else too. I had a case involving a guy that fell asleep against the wheel of an 18-wheeler, totally drunk out of his mind. It turned out to be a great case that settled for 7-figure policy limits. I've never driven an 18-wheeler, but what I learned through studying what's involved in driving an 18-wheeler is before you get into that truck and you start it up and drive away, you got to walk around it and look underneath it. The point I'm trying to make is from a factual perspective, you have to learn what's involved. Just like John said, you have to know your case. You have to become an expert in whatever it is that case is about from a practical, down on the ground level. Okay. If you're doing a sexual molestation case, how are these children supervised? How many people are there to supervise them? Are they using men to look in on females? Okay. I've seen this stuff, at hospitals and psychiatric facilities and stuff where girls are molested. You need to understand from a factual perspective how it all works. These aren't legal issues. You got to do a lot of homework, and then you'll know who to ask for and what to ask for. You know, if they have no policy, when before you even do the PMK notice of depo and request for docs, they're going to ask for the policies on all these things. If they have no policies, start
Right.
smiling.
So you do your homework about not just your case, but the industry before you even send out the PMK notice with the request for production.
Absolutely. Absolutely. And for those out there, I've sent out 7 different notices of depositions involving dangerous condition of public property, general premises liability, sexual molestation, truck accidents, a whole bunch of different things that people on the plaintiff side can look at that will give them some sense of how it, what to do and how to put it together.
Do you typically do, one big PMK notice for the entity defendant of, whatever, all 30 categories of all the issues involved in the case and let them kind of parse it out? Or do you do little pieces at a time of, we're going to do this aspect of the case with this PMK notice and then this aspect of the case with another one?
I'm so glad you asked that question because I wanted to ask John a question. I typically do one notice of PMK, okay? And the question that I was going to ask is, how would one handle it where a defense attorney designates, let's say, 10 different PMKs, okay? And, depending upon who the plaintiff's attorney is and what their resources, that could obviously be discouraging or a disincentive if they don't have the resources to be able to do that. And strategically, from the defense side, John, is that something that's done? And from the side of the bench, how would that be handled?
Well,
right.
I've never seen that, I have to say, but it occurred to me as John was speaking.
Right.
Okay. Well, I alluded to this earlier. I mean, I have always preferred, assuming I'm not running into resistance from my client, I'd rather have 2 or 3 or 4 people designated as the PMKs because they actually know what they're talking about on the subjects. Your prep time is going to be less with the person. You can be comfortable as a lawyer. They're probably not going to say something that wasn't really within their expertise, because the last thing you really want to do is have somebody testify and they're really speculating. They don't know the answer to it, and they're I'm designated as the person most knowledgeable, so therefore I should answer this question, and they really don't know. It's I think you got to have a heart-to-heart with your client as the lawyer. If your client is trying to pull up somebody as the PMK designee, that really is not the one, because my experience has been, I've run up against a lot of really good lawyers, and I don't want those people. I mean, they will try the case unless we're going to pony up a lot of money for settlement, and it's going to be a tough trial, and so I would rather do that. But again, a lot of it, I feel also, that's why I like the meet and confer rules in federal court, and the obligations under Rule 26. To have your early discussion. I mean, now you've got early disclosures in state court, which is good. I think it's all helpful. And I think it's good for the defendant, even though some people think it's onerous and yada, yada, yada. But I think you're better off as a lawyer, because now you're actually having a dialogue, like the dialogue with the plaintiff's lawyer. Frequently in the employment arena, I would know some of the plaintiff's lawyers. So I knew what their tendencies were. We litigated before. I might have a discussion with them the minute the complaint comes in, before there's any obligation, just to kind of talk about where are we going in this case, and let's do it civilized, so we're both prepared. But like I said, I would prefer to have 5 PMK designees that actually know what they're talking about than one person is stuck. Because it's horrendous when you're trying to prepare somebody, at least in the employment area, and they really don't know. They're not capable of knowing enough to give a good answer. You look at the filings in state court now, 2/3 of the cases being filed are employment cases. So we're not talking about a little industry that's going away. Employment lawsuits are coming full barrel. So you got to know what you're doing in this area.
So those are all good points. Question is, and I think we have some of your objections from previous cases in the materials. So one scenario is a plaintiff's counsel.
Necessarily
That's
mine.
so they set a notice of the PMK with 20 categories. And after conferring with your client, you're acting in good faith. Turns out it's 4 people. And it's just say each of the 4 is going to talk about 5 categories. So presumably you would have a conversation with plaintiff's counsel saying, look, we have 4 PMKs, 1 through 5, 6 through, right? So this PMK is going to talk about categories 1 through 5, just make it easy. Do you then let the plaintiff's counsel question them about the other categories? Or just, it's only these 5, that's all we're talking about, and then PMK number 2, we'll talk about the others.
I'd probably have a discussion ahead of time with the plaintiff's lawyer about that. But no, I would probably object because it's outside the scope of what this person has been designated for. You may still let them testify, but you do object. You don't want to not object. I mean, just like sometimes there are in your preliminary objections, you'll then have a meet and confer. There are times where you need to go in for a motion to compel before the deposition's taken. I mean, those are all strategy decisions, and I don't want to get bogged down in it for our program today. I mean, I could spend 4 hours going through this in a training program with lawyers, but there are times. I think it's always wise. You should be responding in your response who your designee is going to be, but at the very least, have a phone discussion with the plaintiff's counsel. In my opinion, you should do that in advance. It'll make it a lot smoother. You're not likely to get into a lot of motion practice later on if you have these discussions. And I'd rather, when you were a judge, Judge Pfeffer, I would rather be in front of you on somebody's motion where I did my darndest to have meet and confers with the plaintiff's lawyer before they became unreasonable. Because my declaration to you on why I shouldn't be sanctioned would be all about all the efforts I made with plaintiff's counsel to get the PMK depositions in an orderly process. But
a question for John. Sorry to cut you off. One thing that has come up in questions before and during is this scenario happens a lot where it turns out the PMK is also somebody at the company or entity who would be deposed in his or her individual capacity. This happens rather often. I mean,
Right.
My guess is you would want, this is the PMK depot, start and stop when we're done, and then the individual depot. But how would you deal with those scenarios where the PMK is also an individual recipient who's going to be deposed?
I would want to spend time with the PMK and that individual so I feel comfortable as the defending lawyer which of the 2 approaches I want to take. Because there are times that you do want it just the PMK. There are other times you got all kinds of practical considerations. If you're bringing in somebody from out of state and there's travel time involved, it's not a remote depot. You may have to deal with that. You got to weigh the risks one way or the other. You keep in mind too, you've got the 7-hour day depots. And you have, in federal court, you got 10 depot limits unless you go back for leave of court. So if you're going to have different depositions, you got to take all those factors into consideration. It's all strategic how you want to do it. But again, it's not a simple answer. It really depends on the case. It depends on how sophisticated the witness that you're designating is. I mean, there have been times where I want to do them both at the same time, for the convenience of the witness who's come in from, Pennsylvania out to California for a depot, save some costs. And there are times where, no, I don't want to do it. There are times strategically where I want to make the plaintiff's lawyer suck up 2 depositions out of the 10. In any event, those are all strategic considerations, in my opinion.
Right. Makes sense. And then Sandy, kind of the flip side of that question to you is you learn before the PMK deposition that the PMK is actually, an employee or an agent or an officer who you were going to depose in his or her, kind of official capacity. Would you want 2 separate discrete depots the PMK depo, and then I'm deposing you? Or would you kind of prefer to blend them together?
No, just from a financial perspective and a perspective of economy of time, I think it's best to just blend them together. I don't see any detriment to blending them together. Whereas, you've got two different depositions and 2 different days and 2 different schedules, and I don't see any practicality to doing them separately at all.
Right.
Typically,
Perhaps get a stipulation for more time since you're kind of blending two together.
If that's necessary.
Right. I'm sorry, John. I think I cut you
Look,
off.
one of the things John said,
Sorry.
hold on, John.
Yeah, what's that? Sorry.
One of the things John said, and I really want to emphasize it,
Yes.
is working with your opponent, working civilly, benefits everybody all the time. So, if you need to do that, that you work that out with your opponent. You should work that out with your opponent. Now, there's one other thing, John. Can I just take another minute?
Absolutely.
Yes.
Okay, with PMK depots, you're going to have 2 kinds of people there. You're going to have the scared person who's afraid to say anything wrong and get the company in trouble. And you're going to have the person who wants to help. Oh, our company is safe, and we have all these policies. And let me tell you how safe we are and how we follow all these policies and procedures. Okay, we haven't talked about it at all, but I think it's better when you're doing these depositions to do them with honey rather than to hardball them. I think you'll get much more. And in the end, that helps everybody, because if it's not a good case, the defense attorney needs to know that and be able to evaluate that so he can properly advise his client, and when he comes to mediation with his client, knows what the right thing is to do given the merits of the case. Thank you, John. Sorry to interrupt.
Makes sense. Yes, John.
Well, I kind of quipped at Sandy because in my opinion, a lot of the plaintiffs' lawyers, they'd like to have both the PMK and the individual depot in one, because Sandy's right. From an economy standpoint, it's better to do that. And if plaintiffs' lawyers they don't want to take 30 depositions, they'd rather take 5, because they're trying to keep their time commitment down to maximize their return on investment. But from the defense side, I think you want to do a good job because the employment area is so explosive now. The number of big 7-figure verdicts are massive out there. You can't screw around with this stuff anymore. I mean, it's a different day and age in 2024 than it was when I started out in 1975. So,
right. As a question for John, this question's come up quite a bit in the Q&A and also before today. And so given what the statute says is you go to your client and says, there's no one here who knows, the person who's the most qualified is retired, somewhere on the beach in, Tahiti, or there's no one here. And it's just me. And the policy was before my time and I don't know anything. Like, have you ever had a situation where you do actually pull in a former employee who's no longer with the defendant, your client, as a PMK?
absolutely.
Okay.
I don't know how it doesn't happen sometimes. I mean, because you will have people that move around and they may have gone. Keep in mind, a lot of employers with manager type people, and especially the higher up that they are, you will have usually some kind of severance arrangement with somebody, getting them contractually bound that they will continue to cooperate with the company if there's any litigation ensuing later on that they may have some information on. So, from the employer perspective, it's very helpful to have it, but then the plaintiff's lawyer, if they're smart, would hoist somebody by their own petard if they then didn't go out and get that former employee to come back and provide information. But those are all strategy considerations as well. But I would rather reach out. I think you have a duty. I really would rather say we tried to reach so-and-so because that person was there when that was our HR policy way back then, and yada, yada, yada. I'd rather reach out and try and get them. If they refuse to come, the plaintiff's lawyer can go out and subpoena people that are former employees too. I don't know if you've ever done that, Sandy, but I see in the products liability and a lot of the stuff you do, Sandy, I would imagine that comes up more often, that the employer, there's nobody there that knows what they did 30 years earlier. In the employment arena, that doesn't happen that much.
Yeah.
Right.
Have you seen that situation, Sandy? Yes.
Only in the area of sexual molestation, because everything else is contemporaneous. If somebody falls on a sidewalk or falls in a supermarket or is in a car accident or is beat up by a security guard or whatever it is, that's contemporaneous, and there should be somebody in that company or in that government institution who could talk about what the policy is now, or during the last 2 years or whatever it is, when that accident happened. But here's a question I just want to throw out, if I can. Since we are all mediators, okay, in those cases where there is no PMK or the PMK does a poor job, how do people use those facts at mediation? And from a defense perspective, John, what does one advise the client? I mean, it would seem to me that's a case that crystallizes where somebody would say, we have to go to mediation. The last thing we want to have is you in front of a jury, where there's no policy, where nobody knows a policy, where nobody was there for the policy.
Yeah, I think that we're coming up to that. So John, quickly, if you have a response to that.
Yeah. So as a mediator, what do I do with that?
Well, no, not as a mediator, but as somebody representing a company who's stuck with that kind of testimony.
Right.
What do you do? How do you use that at mediation?
Mediate and settle.
Yes, exactly.
Well, you really do. I mean, you try and get the best settlement you can. You pray that your relationship with plaintiff's counsel is one that they're not going to kill you.
Right, exactly. So I know we're close to the end. So Sandy, if you have anything briefly in closing, and John, the first Sandy.
My closing is this. I would just emphasize to everybody out there in Radio Land, you have to think strategically. You want to think about how your PMK depots interlock with your client's depots and the expert depots, both yours and the opponent. You want to be thinking broadly about all of that when you put it all together, when you put your notice together, when you put your request for docs together, and when you do that deposition. If you think that way, you'll be doing your client a good job. You'll be doing a good job for your client.
Thank you. And John, briefly in closing?
Yeah, and briefly.
30 seconds.
All right, 30 seconds. Know your case, know your facts, know the allegations, know your client, prep your witnesses. Spend a lot of time with your PMK deponents to make sure they know how to answer questions. Role play with them. Don't just send them in there because the questions in a PMK deposition are different than the specific, oh, you were the HR or you were the manager that was dealing with the employee on the assembly line. That's very specific. The PMK is a whole different ballgame. So you need to prep, and you need to go through potential questions with your witness. You're strategically, it can be a disaster if you don't.
Right. So definitely prep work on both sides, the noticing, taking attorney and the one defending the depot. There's certainly work to be done on both sides to get the most, effective use of the PMK depot. Well, thank you, both of you. Learned a lot. And I know we answered a lot of questions that were in the Q&A. And so I, really appreciate your time and sharing your knowledge.
This is great.
Yeah.
Thank you so much for keeping it on time. We are 1 o'clock on the dot. I just wanted to thank all of our speakers for this wonderful webinar and this engaging discussion.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.